Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship. Divorce law is an incredibly nuanced field that varies significantly by jurisdiction, state statutes, and individual circumstances. The historical trends and case studies discussed here are intended to provide a broad professional overview of the industry and should not be used as a substitute for professional counsel. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional in their specific state before making any decisions regarding their legal or financial status. Imagine for a moment that you are standing in a courtroom in 1924. To get a divorce, you don't just need a reason. You need a villain. You need to prove with photographic evidence or witness testimony that your spouse committed an act of moral turpitude, adultery, extreme cruelty, or desertion. If you both want the divorce, you are legally barred from getting one because collusion is a crime. Fast forward to today, and the divorce industry in the United States has transformed into a $50 billion a year professional machine. It is an industry that manages more domestic wealth than the venture capital sector and touches the lives of nearly half of all American families. We often hear about the emotional toll of a split, but we rarely talk about the professional evolution of the person standing at the center of the storm, the divorce attorney. For over a century, this profession has evolved from a social pariah lurking in the shadows of the legal world to a high-stakes architect of financial and familial restructuring. This video is the first part of a deep-dive masterclass into a century of professionalism within the American divorce system. Today, we are solving a problem that most people don't realize they have until it's too late: the fundamental misunderstanding of how the legal machinery actually functions. By the end of this series, you will understand the historical trends that shape modern statutes, the tactical shifts in how assets are protected, and the reality of how the legal profession navigates the most volatile human emotions to reach a resolution. This isn't just about the law. It's about the evolution of a professional class that has been tasked with the impossible, quantifying the value of a life lived together. To understand where we are in 2026, we have to look back at the radical professional shift that began in the 1920s. During this era, the divorce attorney was a title many elite law firms avoided. It was seen as dirty work, focused on private investigators peeking through keyholes and manufactured scandals. However, a professional niche began to emerge in places like Reno, Nevada. This gave birth to what historians call the divorce colonies. Because most states had incredibly restrictive laws, attorneys in Nevada leveraged a shorter residency requirement to create a specialized legal product. This was the first time we saw the divorce attorney act not just as a litigator, but as a lifestyle and jurisdictional consultant. They weren't just filing papers, they were navigating a complex web of interstate recognition of decrees. This era established a historical trend of jurisdictional shopping that still influences how high-net-worth individuals approach filing today. An attorney in 1926 had to be a master of the 6-week cure, guiding clients through the professional requirements of establishing a new domicile just to access a more favorable legal framework. The transition from this fault-based era to our modern system didn't happen overnight. For decades, the professional standard was adversarial by necessity. If the law required a guilty party, the attorney's job was to be a prosecutor of the spouse. This created a culture of extreme conflict that defined the profession for 50 years. In the 1950s, for example, a divorce attorney's primary tool wasn't a spreadsheet. It was a subpoena for hotel records. The potential outcomes of these cases were often binary. You either proved fault and received a settlement, or you failed and remained legally bound. This professional landscape forced attorneys to be aggressive, often exacerbating the very trauma they were hired to resolve. It wasn't until the 1960s that the professional tide began to turn, leading to the single most significant legal shift in American history: the no-fault revolution. When California passed the Family Law Act of 1969, signed by then-Governor Ronald Reagan, the role of the divorce attorney was fundamentally redefined overnight. The professional requirement to prove guilt vanished. While this was intended to reduce conflict, it actually made the professional's job much more complex. Instead of searching for a smoking gun of adultery, the attorney now had to become a sophisticated financial analyst. The focus shifted from who did what to who owns what. This ushered in the era of equitable distribution and community property standards that we navigate today. The attorney had to evolve from a moral arbiter into a tactical negotiator who understood tax codes, pension valuations, and the long-term appreciation of real estate. Consider the complexity of a modern case study in 2026. A divorce attorney today is often managing a portfolio that includes traditional real estate, diversified 401(k)s, unvested stock options, and increasingly, digital assets like cryptocurrency or intellectual property from social media presence. In the 1980s, an attorney might argue over who gets the family sedan. Today, they are arguing over the valuation of a lifestyle brand or the future royalties of a digital creator. This requires a level of professional interdisciplinarity that was unheard of even 20 years ago. The modern practitioner must coordinate with forensic accountants to track hidden assets in decentralized finance platforms and work with child psychologists to draft parenting plans that account for a world of remote work and global mobility. The professionalism in this field has also seen a massive shift toward alternative dispute resolution. In the late 20th century, the pit bull attorney was the gold standard. The trend in the 2020s, however, has moved toward the collaborative professional. Historical data suggests that cases resolved through mediation or collaborative law often result in higher long-term compliance with the final decree than those decided by a judge. This is because the professional has shifted their focus toward future-proofing the agreement. A masterclass level attorney isn't just looking at the bank balance today. They are projecting the cost of college tuition in 15 years, the impact of inflation on alimony payments, and the potential outcomes of a volatile housing market on the sale of a primary residence. Furthermore, we must address the business of the profession. To understand the divorce attorney, you must understand the economics of the firm. The billable hour model has been the professional standard for a century, but we are seeing a historical shift toward flat fee structures and unbundled legal services. This is a response to the pro se movement, individuals representing themselves because of the rising costs of traditional litigation. Professional attorneys are now having to justify their value in an era where AI can generate a basic settlement agreement in seconds. The value of the professional in 2026 lies in gray area navigation. AI can calculate a 50-50 split of a bank account, but it cannot negotiate the nuances of a right of first refusal in a custody schedule or argue why a specific inheritance should be considered separate property, despite being commingled for a decade. As we move through this 10-part series, we will break down these technical silos. We will look at the anatomy of a high-stakes deposition, the shadow work of paralegals who do the heavy lifting of discovery, and the psychological burden of being a professional who spends 8 hours a day in the middle of other people's worst moments. The history of the divorce attorney is the history of the American family itself. It is a mirror of our changing values regarding gender, money, and the definition of a successful life. By looking at the data, the historical trends, and the case studies of those who paved the way, we can see that the professional divorce attorney isn't just a legal representative. They are the cleanup crew for the American dream, tasked with dismantling a unit in a way that allows the individual parts to keep functioning. We are going to peel back the curtain on this $50 billion industry to show you exactly how the gears turn, why the system is designed the way it is, and what the future of professional family law looks like in an increasingly digital and globalized society. This is the deep dive you've been waiting for. This is the century of professionalism. To understand the absolute power of a modern divorce attorney, you have to look past the courtroom drama and into the grueling high-stakes reality of the discovery process. If the 1920s were defined by the private investigator in a trench coat, 2026 is defined by the forensic accountant with a supercomputer. This is where the professional war is truly won or lost. It is a phase of litigation that has evolved from simple paper pushing into a sophisticated intelligence operation designed to map out the entire financial and social DNA of a marriage. Imagine a man named David living in Austin, Texas. It is 2026, and David is a high-level executive at a biotech firm. On the surface, his finances look standard. A high salary, a 401(k), and a joint mortgage. But David has spent the last decade building a complex web of interests. He has unvested restricted stock units, a silent partnership in a local restaurant group, and a significant portion of his personal savings moved into decentralized finance protocols and cold storage crypto wallets. When David's spouse, Sarah, files for divorce, her attorney doesn't just ask for bank statements. They launch a full-scale lifestyle audit. This is the professional standard of the modern era. In a lifestyle audit, the attorney isn't just looking at what David says he earns. They are looking at what he spends. Historical trends in family law show that people rarely hide their income perfectly, but they almost never hide their consumption. If David claims an annual income of $200,000 but maintains a lifestyle that requires $500,000, including luxury travel, private club memberships, and high-end vehicle leases, the professional divorce attorney uses that delta as a weapon. They work backward from the expenses to find the hidden income streams. This process involves a step-by-step deconstruction of credit card processing data, geofencing social media posts to verify luxury travel locations, and even analyzing Amazon delivery frequencies to establish a standard of living. The primary tool for this extraction is the request for production. In the 1980s and 90s, this was often used as a tactical exhaustion technique known as a box drop. An attorney would send 500 boxes of disorganized, unindexed paper to the opposing counsel's office on a Friday afternoon, forcing them to spend thousands of billable hours just to find one relevant receipt. Today, the professionalism of the field has moved toward e-discovery. In 2026, the battle is over metadata. A professional attorney is no longer satisfied with a PDF of a tax return. They want the original Excel files with the formulas intact. They want the Slack messages from David's startup that might mention a future IPO. They want the metadata from a photo taken in the Cayman Islands to prove David was there on a specific date when he claimed to be on a business trip in Ohio. This brings us to the interrogatory, which is a series of written questions that the opposing party must answer under penalty of perjury. A masterclass-level divorce attorney doesn't ask broad, easily avoidable questions. They use a precision-guided approach. Instead of asking, "Do you have any offshore accounts?" they ask, "List every financial institution, including digital asset exchanges and neobanks, where you have held an interest of more than $1 in the last 5 years." They are setting a trap. If David fails to disclose a small, forgotten Venmo balance or a dormant Coinbase account, the attorney can use that omission to destroy David's credibility in front of a judge. In the professional legal world, once you are caught in a single lie regarding discovery, the court often presumes that everything else you say is also a fabrication. The role of the forensic accountant in this process cannot be overstated. By 2026, these professionals have become the right hand of every top-tier divorce attorney. They perform what is known as a tracing analysis. Case studies in high-net-worth divorces often center on the concept of commingling. Suppose David received a $50,000 inheritance before he married Sarah. Historically, that is separate property. But if David deposited that money into a joint checking account and used it to pay the mortgage for 10 years, it has likely become marital property. The attorney and the forensic accountant must perform a penny-by-penny reconstruction of that account over a decade to argue whether those funds can still be carved out. This level of detail requires hundreds of hours of professional labor, and the potential outcomes can mean a difference of millions of dollars in the final settlement. We also see a historical shift in how the law treats the professional goodwill of a business. If David owns a medical practice or a consulting firm, the attorney must determine how much of that business's value is tied to David personally versus the business as an entity. This is a highly technical professional debate. One side will argue that the business has zero value without David's specific skills, while the other will use market data to show that the brand, the client list, and the systems have an intrinsic value that Sarah is entitled to a portion of. This isn't just an argument. It's a battle of expert witnesses, each bringing decades of professional experience to the stand to quantify the intangible. The psychological toll of this paperwork war is a deliberate part of the professional strategy. In the legal industry, this is sometimes referred to as litigation of attrition. The goal is to make the process so invasive, so expensive, and so transparent that the hiding party eventually folds and offers a more favorable settlement just to make the scrutiny stop. A professional attorney knows that most people value their privacy and their time more than they value the last 10% of an asset split. By 2026, the sheer volume of data available, from Uber trip histories to Netflix viewing habits used to prove cohabitation, means there is nowhere left to hide. As this century of professionalism has progressed, the attorney has also had to become an expert in the duty of candor. There are strict ethical guidelines that prevent an attorney from knowingly presenting false information. This creates a fascinating professional tension. An attorney must represent David zealously, but they cannot help him hide assets if they know they exist. This leads to a complex dance where the attorney must educate their client on the risks of non-disclosure, explaining that the cost of being caught hiding an asset is almost always higher than the cost of simply sharing it. In many jurisdictions, if a judge finds that you intentionally hid an asset, they have the power to award 100% of that asset to the other spouse as a penalty. This evolution of discovery has turned the divorce attorney into a master of information architecture. They aren't just lawyers, they are librarians of a failing marriage, cataloging every debt, every asset, and every broken promise in a format that a court can digest. But as we move from the cold, hard numbers of the financial discovery, we enter an even more volatile arena. Because once the money is mapped out, the battle shifts to the one thing that cannot be easily quantified on a spreadsheet: the children and the future of the family unit. In the next part, we are going to look at the professionalization of custody. We will examine how the legal system moved from the tender years doctrine, which almost always favored mothers, to the modern standard of the best interests of the child. We will dive into the role of guardian ad litems, custody evaluators, and the high-stakes chess match of creating a parenting plan in a world of 50-50 splits. How does an attorney argue for a parent's fitness when every text message and every social media post is now a piece of evidence? The war over the bank account was just the beginning. The real battle is about to start. To understand how the battle for the child became the most scientifically rigorous and professionally complex part of a divorce, we have to look at the death of the tender years doctrine. For most of the 20th century, the legal system operated on a simple, albeit gender-biased, assumption that mothers were inherently better suited to care for children during their tender years. This wasn't just a social preference. It was a professional shortcut that attorneys used to predict potential outcomes with high accuracy. If you were a father in 1955, unless you could prove gross moral negligence on the part of the mother, your role was historically relegated to every other weekend and a child support check. But as we stand in 2026, that professional shortcut has been replaced by the best interests of the child standard, a multifaceted legal framework that requires a divorce attorney to act more like a clinical investigator than a traditional litigator. The modern professional doesn't just argue that a parent is good. They have to prove a parent's fitness using a mountain of empirical data. This shift has given rise to a new class of professional consultants, known as custody evaluators and guardian ad litems. Imagine a case study involving a mother named Jessica in Seattle. Jessica is a high-performing surgeon, and her spouse, Michael, has been the primary caregiver for their 2 children for 8 years. In the 1970s, Jessica's career might have been seen as a secondary factor to her motherhood. In 2026, her attorney must navigate a professional landscape where Michael's role as the primary caregiver gives him a significant historical advantage. The attorney's job is no longer to argue gender roles, but to meticulously document Jessica's involvement in every aspect of the children's lives. This documentation process is a step-by-step forensic reconstruction of a parent's relationship with their child. The attorney will first demand access to school portals like PowerSchool or Canvas. They are looking for the digital footprint of parental involvement. Did Jessica log in to check grades? Did she respond to emails from the teacher? They will then move to the pediatrician's records. Who is listed as the primary contact? Who signed the consent forms for the last 3 years of checkups? In a world of digital parenting, the attorney uses this data to build a narrative of presence. If Michael can show that Jessica was in the operating room for 90% of the children's milestone events, the attorney has to shift the professional strategy toward a concept called quality over quantity, or argue for a future-facing parenting plan that accounts for her high-stakes career while maintaining the children's stability. The most powerful professional in this arena is often the guardian ad litem, or JL. This is an attorney or a mental health professional appointed by the court specifically to represent the interests of the children. In a high-conflict divorce, the JL is the eyes and ears of the judge. A professional divorce attorney knows that the GAL's recommendation often carries more weight than any other piece of evidence. This has changed the way attorneys prepare their clients. In 2026, an attorney doesn't just tell their client to be a good parent. They provide a professional roadmap for the JL interview. This includes everything from the physical layout of the home, ensuring the children have dedicated, age-appropriate spaces, to the client's ability to demonstrate co-parenting communication. One of the most significant historical trends we are seeing in 2026 is the rise of the rebuttable presumption of equal shared parenting. Many states have moved away from the primary and secondary parent labels, instead starting at a baseline of a 50-50 split of time. However, the professional complexity lies in the logistics. This is where the attorney must become an architect of time. They are tasked with drafting parenting plans that go far beyond the old-fashioned alternating weekends. They have to account for the 2-2-3 schedule, the 2-2-5-5 schedule, or the week-on week-off rotation. Each of these has different potential outcomes for the children's stability and the parent's ability to work. A professional attorney must analyze the commute times between the two residences, the proximity to the children's school, and even the extracurricular schedules to determine which plan is actually sustainable. Consider the role of digital evidence in modern custody battles. In the past, he said she said was the standard of evidence. Today, the divorce attorney is sifting through years of text messages and social media posts. Imagine if a parent, let's call him Robert, claims he is a sober and dedicated father, but his public Instagram stories from 6 months ago show him at a late-night party while he was supposed to have the children. Or imagine if a mother's text messages show a pattern of gatekeeping, purposefully withholding information about a child's soccer game to make the father look disinterested when he doesn't show up. The attorney uses these digital trails to establish a pattern of behavior. In 2026, professionalism in custody law means being an expert in metadata and authentication, ensuring that the screenshot being presented in court hasn't been edited or taken out of context. We are also seeing the professionalization of the children's voice through the use of child-inclusive mediation. Historically, children were kept out of the legal process to protect them from trauma. However, case studies in the mid-2020s have shown that for older children, having a structured, professional way to express their preferences can lead to more durable agreements. The attorney coordinates with a child specialist who meets with the children and then brings their perspective back to the negotiating table. This isn't about letting the child choose which house they live in. It's about a professional analysis of the child's specific needs, such as wanting to stay in their current neighborhood to be near friends, or needing a specific environment to manage a learning disability. Step by step, the creation of a modern parenting plan in 2026 also includes clauses for virtual visitation and digital communication. This is a far cry from the landline phone calls of the past. Professional attorneys are now drafting specific times for FaceTime or Zoom calls, and even rules for communication through specialized parenting apps like Our Family Wizard or Talking Parents. These apps are designed to create a court-admissible record of every interaction, removing the ability for one parent to claim they never received a message. This professionalization of communication is a direct response to the historical trend of high-conflict parents using their children as messengers. By moving all communication to a monitored platform, the attorney creates a layer of professional accountability that protects the children from the parents' friction. As we look at the evolution of these custody battles, we see that the divorce attorney has transformed from a legal advocate into a manager of family dynamics. They are coordinating a team of experts, psychologists, educators, and forensic digital analysts to present a version of reality that the court can use to make a life-altering decision. The stakes are no longer just about who gets the house. They are about the psychological trajectory of the next generation. But as difficult as the custody battle can be, there is another professional hurdle that often proves to be even more contentious because it combines the volatility of the children with the cold, hard reality of long-term financial survival. While the custody battle defines the family's future, the question of spousal support or alimony defines their standard of living for years to come. In the next part, we are going to dive into the death of the lifetime alimony and the rise of the rehabilitative support model. We will look at how attorneys calculate the value of a career that was put on hold, the impact of the 2018 tax law changes on alimony payments, and the high-stakes world of vocational evaluations. How does an attorney prove that a spouse who hasn't worked in 20 years is capable of earning a six-figure salary today? The math of the split is about to get even more personal. The transition from permanent alimony to what we now call rehabilitative or durational support represents one of the most significant professional shifts in the history of family law. To understand the current landscape of 2026, we have to look back at the historical trends that dismantled the idea of a lifetime pension after marriage. For much of the 20th century, alimony was often viewed through a quasi-punitive lens. If a husband was found at fault for the breakdown of the marriage, alimony was the financial consequence. However, with the arrival of no-fault divorce and the landmark 1979 Supreme Court case versus Orr, which established that alimony must be gender-neutral, the professional focus shifted toward economic necessity and the concept of the marital partnership. Imagine a case study in 2026 involving a couple we will call Mark and Linda. They have been married for 22 years. Mark is a senior partner at a specialized engineering firm, earning a consistent high six-figure income. Linda, who holds a master's degree in architecture, stepped away from her career 2 decades ago to manage the household and support Mark's professional trajectory, which involved frequent international relocations. In the 1960s, a divorce attorney for Linda would have walked into court expecting permanent alimony, until she either remarried or passed away. In 2026, the professional reality is vastly different. Linda's attorney must now build a case for rehabilitative support, which is designed to provide a financial bridge until Linda can reasonably be expected to support herself. The first step-by-step hurdle in this process is the vocational evaluation. This is where the divorce attorney brings in a third-party professional, a vocational expert, to determine Linda's earning capacity. This isn't a simple guess. The expert performs a multi-stage analysis. First, they conduct a transferable skills analysis. They look at Linda's master's degree, her past work history from 20 years ago, and her current cognitive and physical abilities. Then they cross-reference this with real-time labor market data for 2026. They look at the demand for architects in her specific geographic area, the current salary ranges for entry-level or mid-career reentrants, and the specific certifications Linda would need to obtain to become competitive again. The potential outcomes of this evaluation define the entire negotiation. If the expert determines that Linda can earn $80,000 a year after 18 months of recertification, Mark's attorney will argue that alimony should only last for those 18 months, plus perhaps a short tail for job searching. Linda's attorney, conversely, will use the same data to argue that 20 years out of the workforce has created a permanent career gap that can never be fully bridged, requiring a longer duration of support to maintain a lifestyle that is at least somewhat reflective of the marital standard. This is the math of the split. It is no longer about what is fair in a moral sense. It is about what the data says regarding Linda's ability to achieve self-sufficiency. This brings us to a massive professional pivot that occurred because of the Tax Cuts and Jobs Act of 2018. Before this law went into effect, alimony was a highly effective tool for divorce attorneys because it was tax-deductible for the person paying it and taxable income for the person receiving it. This created a tax subsidy that allowed attorneys to find a middle ground. If Mark was in a 37% tax bracket and Linda was in a 12% bracket, the government essentially paid for a portion of the support. Attorneys would use this delta to craft settlements where Mark felt he was paying less and Linda felt she was receiving more. However, for all divorces finalized after December 31, 2018, that deduction vanished. In 2026, every dollar of alimony Mark pays is in after-tax dollars. This has fundamentally changed the professional strategy of the divorce attorney. Because the tax advantage is gone, payers like Mark are much more resistant to long-term support obligations. Attorneys now have to be much more creative, often trading larger portions of property or retirement accounts in exchange for a reduction or elimination of ongoing monthly alimony. This is known as a buyout. A professional attorney will perform a present value calculation, taking a stream of future monthly payments and discounting them to a single lump sum today, to see if a buyout is a better potential outcome for their client. The calculation of the need and the ability to pay has also become hyper-professionalized. In 2026, an attorney doesn't just submit a rough budget. They submit a comprehensive financial affidavit, backed by 2 years of forensic spending analysis. They look at the historical trends of the couple's spending. If the couple spent $15,000 a month on travel, dining, and household maintenance, that becomes the baseline for the marital standard of living. Linda's attorney will argue that she is entitled to maintain a lifestyle that is not drastically inferior to the one she enjoyed during the marriage, especially in a long-term union of over 20 years. But here is where the professional conflict intensifies. The concept of imputed income. If Linda decides she doesn't want to go back to architecture and would rather work in a lower-paying field, Mark's attorney will ask the court to impute income to her. This means the court treats Linda as if she is earning that $80,000 a year, regardless of whether she actually is. In 2026, with the rise of the gig economy and remote work, attorneys are increasingly arguing over what constitutes a reasonable effort to find employment. Is a parent expected to work full-time if they still have a teenager at home? Does a remote job in a different state count as an available opportunity? The professional divorce attorney must stay abreast of employment trends to make these arguments effectively. Furthermore, we are seeing a shift toward durational limits in state statutes. Many states have moved to a formulaic approach where the length of alimony is tied directly to the length of the marriage. For example, the support might last for 30 to 50% of the years the couple was wed. This reduces the unpredictability that plagued the system for decades, but it also increases the pressure on the initial asset split. If Linda knows her support will end in 7 years, her attorney must ensure that the property she receives in the divorce, the house, the investment accounts, the QDROs, is sufficient to sustain her for the decades that follow. The math of the split is a cold, calculated endeavor, but it is the foundation upon which the rest of the post-divorce life is built. In 2026, the professional divorce attorney is a master of these formulas, balancing the vanishing tax benefits against the rising costs of living and the unpredictable nature of the modern job market. They are preparing their clients for a future where the financial ties of marriage are severed more cleanly and more quickly than ever before in American history. But while we have mapped out the income and the support, we haven't touched the most valuable, most sentimental, and often most debt-ridden asset in the entire portfolio. The marital home is often the crown jewel of the estate, but in a world of 6% mortgage rates and fluctuating property values, it can also be a financial landmine. In the next part, we are going to dive into the professional battle over real estate. We will look at the rise of the equity buyout, the nightmare of the co-owned home post-divorce, and how attorneys handle the complex world of separate property contributions to a joint residence. What happens when the house you built together becomes the very thing that prevents you from moving apart? The architecture of the exit is about to get very complicated. In the professional world of family law, the marital residence is often referred to as the anchor of the estate, but in 2026, that anchor is increasingly becoming a lead weight. For a century, the American dream was built on homeownership, and for a century, the divorce attorney's simplest task was often selling that home and splitting the check. But the professional landscape has shifted. We are no longer in an era of 3% interest rates and predictable housing markets. Today, the architecture of the exit requires a divorce attorney to be part real estate broker, part mortgage underwriter, and part psychological counselor. Imagine a case study involving Christopher and Amanda. They bought a suburban home in Northern Virginia in 2019 for $600,000 with a 2.8% fixed-rate mortgage. By 2026, that home is valued at $1.1 million. On paper, they are sitting on $500,000 of equity after commissions and fees. In the 1990s, the attorney would simply advise them to sell, take their $250,000 each, and move on. But in 2026, Christopher and Amanda face a brutal reality. If they sell, neither can afford to buy a new home in the same school district because current mortgage rates have climbed to 7%. Their monthly payment would nearly triple for a smaller property. This has created a historical trend known as the mortgage lock-in effect, where couples who arguably should not be living together are forced into complex, multi-year co-ownership agreements. The first step in any professional real estate analysis within a divorce is the valuation war. A professional attorney never relies on a zestimate or a casual market analysis from a neighborhood realtor. They hire a certified forensic appraiser who understands the specific nuances of court-admissible valuations. The attorney must decide between a fair market value, what the house would sell for today, and an intrinsic value. In 2026, we are seeing attorneys argue over the cost of sale. If Christopher wants to buy out Amanda, should he get a credit for the 6% commission he would hypothetically pay if he sold the house 5 years from now? Historical trends show that courts are split on this. Some judges argue that since no sale is actually occurring, the commission is speculative. Others argue that it is a latent liability that Christopher is assuming alone. The attorney's job is to use case law to tip that valuation in their client's favor by several percentage points, which in Christopher's case, represents a $60,000 swing. Then we enter the high-stakes world of the Moore-Marsden calculation. This is a technical, step-by-step professional formula used when one spouse owned the home before the marriage, but used marital funds to pay down the mortgage. Let's say Christopher bought the house in 2017 with a $100,000 down payment of his own money. He marries Amanda in 2019, and for 7 years, they used their joint salaries to pay the mortgage. Amanda's attorney will perform a Moore-Marsden analysis to determine the community property interest in the appreciation of that separate property asset. It is not a simple 50-50 split of the total growth. The attorney must calculate the ratio of the marital paydown to the original purchase price and apply that ratio to the capital appreciation during the marriage. This requires a professional level of accounting that most homeowners cannot do on a napkin. If the attorney fails to perform this calculation correctly, their client could lose out on hundreds of thousands of dollars in passive appreciation that the law technically views as a marital gift. The most difficult professional hurdle in 2026 is the equity buyout. In previous decades, the spouse staying in the house would simply do a cash-out refinance to pay the other spouse their share. But with 2026 interest rates being significantly higher than the 2019 baseline, a refinance is often financially catastrophic. It would mean giving up that 2.8% rate. To solve this, professional divorce attorneys are increasingly using what is known as an ALTI lien or a second mortgage. This allows Christopher to keep the primary low-interest mortgage in place while taking out a smaller, high-interest loan specifically to pay Amanda her equity. Or, more creatively, the attorney might negotiate a trade. Amanda gives up her interest in the house in exchange for Christopher giving up his interest in his 401k or brokerage account. This is where the professional's deep understanding of tax-deferred versus liquid assets becomes vital. $100,000 in home equity is not the same as $100,000 in a traditional IRA, which will be taxed upon withdrawal. The attorney must normalize these values to ensure a truly equitable outcome. If a buyout is impossible, the attorney may suggest a deferred sale, historically known as a Duke order. Imagine Christopher and Amanda have a 10-year-old child and want to maintain stability until the child finishes middle school. The attorney drafts a professional agreement where Amanda stays in the home for 3 years, while Christopher continues to pay a portion of the mortgage. This is a minefield of potential outcomes. Who pays for a new roof in year 2? What happens if Christopher wants to buy his own home, but cannot qualify because his name is still on Amanda's mortgage? The professional must draft hyper-specific clauses covering everything from a right of first refusal, if one spouse wants to move a new partner into the house, to a precise schedule for repairs and maintenance. In 2026, attorneys are even including clauses about smart home subscriptions and solar panel leases, which have become common complications in modern real estate. We must also consider the tax implications under Section 121 of the Internal Revenue Code. A professional attorney knows that a primary residence allows for a capital gains exclusion of up to $500,000 for a married couple. If Christopher and Amanda divorce before they sell, and only one of them remains in the house, they could lose half of that exclusion. The attorney's professional duty is to time the entry of the final decree, or the sale of the asset to maximize tax efficiency. A failure to account for this could result in a surprise tax bill of tens of thousands of dollars when the house finally sells. As the house is settled, the professional gaze shifts toward the most invisible, yet often largest, asset in the entire American economy, the retirement account. While the house is the most visible symbol of wealth, the pension, the 401k, and the unvested stock options are the engine of future survival. But these assets are governed by a completely different set of federal laws that can override state court orders. In the next part, we are going to dive into the world of ERISA and the QDRO, the Qualified Domestic Relations Order. We will look at the professional nightmare of dividing a military pension, the historical trends in how unvested tech RSUs are handled, and why a mistake in a single paragraph of a retirement order can lead to a client losing their entire future safety net. The bank accounts are empty, the house is divided, but the battle for the golden years is just beginning. How do you split a paycheck that hasn't been earned yet? The forensic hunt for future money starts now. To understand why retirement assets are the most dangerous territory in modern family law, you have to realize that the state court judge who oversees your divorce actually has no direct power over your 401k or your pension. This is a fundamental professional paradox that every high-level divorce attorney in 2026 must navigate. While a judge can order the house to be sold or the bank accounts to be drained, retirement accounts are governed by a massive, complex federal law, known as the Employee Retirement Income Security Act of 1974, or ERISA. This federal shield was designed to protect workers from losing their safety nets, but in a divorce, it acts as a gatekeeper that requires a very specific, secondary legal instrument to unlock: the Qualified Domestic Relations Order, or QDRO. Imagine a case study involving a couple named James and Elena. James has spent 25 years as a senior systems architect for a major defense contractor. Over that quarter century, he has amassed a 401k valued at $1.2 million and a traditional defined benefit pension that would pay him $6,000 a month upon retirement. Elena, who spent 15 years raising their children before returning to work as a freelance consultant, has a Roth IRA with $50,000. In the eyes of a professional divorce attorney, James's retirement assets are not just numbers on a screen. They are a multi-layered geological formation of separate and marital property. The first step-by-step professional hurdle is the segregation of premarital value. James didn't start the marriage with zero. He had 5 years of service before he met Elena. A professional attorney in 2026 uses a tracing expert to determine the starting balance and, more importantly, the passive appreciation on that starting balance. If James had $50,000 in his 401k on the day he said "I do" that money, and the growth it generated over the next 20 years is arguably his separate property. The attorney must calculate the marital portion by subtracting the premarital value and its proportionate growth from the total. This isn't a simple subtraction. It requires an analysis of market fluctuations and contribution history to ensure Elena isn't inadvertently taking a share of what James earned before they ever met. Once the marital share is determined, the attorney must draft the QDRO. This is where the professionalism of the field truly separates the masters from the novices. A QDRO is a separate court order that is sent to the plan administrator of James's employer. The administrator has the power to reject the order if a single word is out of place. One of the most common professional errors in historical trends is the failure to address survivorship benefits. Imagine if the QDRO is finalized, but it doesn't explicitly state that Elena is to be treated as the surviving spouse for her portion of the pension. If James passes away 2 years after the divorce but before he starts collecting his pension, Elena's entire share could vanish back into the company's pocket. The attorney's job is to ensure that the order is qualified and that it protects the recipient's interest against the death of the participant. Now let's look at a 2026 specific complexity: unvested restricted stock units, or RSUs. In the tech and corporate world, a significant portion of a professional's compensation is often tied to stock that hasn't been earned yet. James might have 5,000 RSUs that vest over the next 4 years. His attorney will argue that since James has to keep working for 4 more years to get that money, it is future income and should not be split. Elena's attorney will counter with the Marlowe or Benson formula, historical legal standards that treat unvested options as a form of deferred compensation for work performed during the marriage. The professional calculation used here is the time rule. The attorney creates a fraction. The numerator is the amount of time James worked at the company during the marriage, and the denominator is the total amount of time James must work to vest the shares. If James was married for 3 of the 4 years required for vesting, 75% of those shares are considered marital property. However, in 2026, attorneys are also dealing with performance-based RSUs. These are shares that only vest if James hits specific corporate milestones. This adds a layer of professional uncertainty. The attorney must draft an if, as, and when order, meaning Elena only gets her share if James actually hits those targets 3 years from now. This keeps the file open for years after the divorce is technically over, requiring a level of professional oversight that can be exhausting for both the client and the firm. We also see a fascinating historical trend regarding Social Security benefits. While Social Security cannot be split by a state court or a QDRO due to federal law, it is a critical piece of the professional puzzle. If James and Elena were married for at least 10 years, Elena is entitled to collect a benefit based on James's earnings record once they reach retirement age, provided she remains unmarried. This doesn't take a single cent away from James's own check. A savvy divorce attorney in 2026 will often look at the calendar and, if the marriage is at 9 years and 6 months, they might advise their client to slow down the process. Waiting those extra 6 months to finalize the divorce can result in a lifetime of additional monthly income for the lower-earning spouse, paid for by the federal government, not the ex-spouse. This is the definition of professional due diligence. Furthermore, we have to address the tax traps of the 401k split. In 2026, the cost of living has made liquidity a primary concern. If Elena receives $400,000 from James's 401k via QDRO, she has a one-time opportunity to take a cash distribution without the standard 10% early withdrawal penalty usually applied to people under age 59 and a half. However, she still has to pay ordinary income tax on that money. A professional attorney must warn her that while the penalty is waived, the IRS will still view that $400,000 as taxable income, potentially pushing her into the highest possible tax bracket for that year. The attorney might instead suggest rolling the funds into a separate IRA to defer the taxes, but this requires a careful analysis of Elena's immediate needs versus her long-term security. As we move through the 2020s, the gray divorce trend, couples over 50 splitting up after long marriages, has made these retirement calculations the focal point of the entire profession. When there is no house left to fight over and the children are grown, the retirement account is the only thing standing between a comfortable third act and poverty. The attorney's role has shifted from a mere legal guide to a retirement strategist, coordinating with financial planners to ensure that when the dust settles, both parties have a sustainable path forward. But even as the math of the retirement split is finalized, the attorney's most difficult task often lies not in the numbers, but in the ethics of the battle itself. In a world where every digital footprint can be tracked and every asset can be forensically traced, the temptation to win at all costs can lead a professional down a very dark path. The line between zealous advocacy and professional misconduct is thinner than most people realize. In the next part, we are going to explore the psychology and ethics of the divorce attorney. We will look at the professional burnout rate, the hired gun phenomenon, and the complex reality of representing a client who may be their own worst enemy. How does an attorney maintain their professional standing when they are being paid to destroy a family unit? We are going to go inside the mind of the practitioner to see the human cost of the century of professionalism. The ethics of the exit are more than just rules on a page. They are a daily struggle for the person behind the desk. To understand the psychological warfare of a 2026 divorce, you have to step behind the mahogany desk of the practitioner and realize that the law is often the least important thing happening in the room. For over a century, the professional divorce attorney has occupied a space that is 1 part legal strategist and 3 part unlicensed therapist. This creates a unique professional pressure cooker that has historically led to some of the highest rates of burnout and substance abuse in the entire legal industry. As we look at the state of the profession today, the elite attorney has had to develop a set of psychological defenses and ethical boundaries that are as complex as the financial spreadsheets they manage. Imagine a professional named Marcus. It is 2026, and Marcus has been practicing family law for 15 years. He is currently representing a high-profile client named Ethan, a founder of a successful fintech startup. Ethan is going through a high-conflict split with his spouse of 12 years. From the first consultation, Marcus identifies a historical trend in client behavior: the desire for the hired gun. Ethan doesn't just want an equitable distribution. He wants a scorched earth policy. He wants Marcus to use the children as leverage to lower the alimony payments, and wants to dig through every private text message his spouse ever sent to find a moral failing that he can present in court. In this moment, Marcus faces the ultimate professional test. A century ago, a lawyer might have leaned into this aggression, fueling the fire to increase billable hours. But in 2026, the professional standard has shifted toward conflict de-escalation. Marcus knows that if he follows Ethan's instructions to play dirty, the potential outcomes include a sanctioned legal case, a destroyed co-parenting relationship for Ethan's children, and a personal hit to Marcus's professional reputation with the local judiciary. The modern professional attorney must perform a step-by-step psychological intervention. First, they must validate the client's anger, while simultaneously explaining the tactical disadvantage of that anger. Marcus explains to Ethan that a judge in 2026 views a parent who uses a child as a pawn not as a victim, but as a risk factor. By refocusing Ethan on the objective data, the bank accounts and the parenting schedule, Marcus is performing the invisible work of the profession, protecting the client from their own worst impulses. This brings us to the ethics of the exit and the concept of candor toward the tribunal. Every attorney is bound by a code of ethics that requires them to be honest with the court, even when it hurts their client's case. Imagine if, during the discovery process we discussed in Part 2, Ethan reveals to Marcus that he actually has $500,000 hidden in an offshore shell company that wasn't disclosed in the initial filings. In 1926, the attorney-client privilege might have felt like an absolute shield for this secret. In 2026, the professional rules are much more clear. Marcus cannot knowingly present a false financial affidavit to the court. If Ethan refuses to disclose the asset, Marcus is ethically required to withdraw from the case. This is the motion to withdraw. And in the small tight-knit world of high-end family law, a withdrawal for ethical reasons is a silent signal to the judge that something is wrong. The attorney must navigate this without breaking privilege, often using the professional phrase, "Professional considerations require my withdrawal." It is a delicate dance between loyalty and integrity that defines the modern practitioner. The professional toll of this work is documented in decades of historical trends regarding vicarious trauma. A divorce attorney spends their day absorbing the most toxic moments of other people's lives. They are the ones who have to look at the photos of domestic abuse, read the transcripts of parents screaming at each other, and listen to children crying in recorded depositions. By 2026, law firms have begun to institutionalize mental health support, recognizing that a lawyer suffering from compassion fatigue is a liability to their clients. A step-by-step protocol for modern firms now includes mandatory debriefing sessions for attorneys working on high-conflict custody cases, and the use of AI-driven sentiment analysis to flag when an attorney's own communications with the client are becoming overly emotional or reactive. Let's talk about the client from hell phenomenon. Every professional divorce attorney has a story about a client who refuses to follow advice, calls 20 times a day, and treats the firm like a 24-hour grievance hotline. In 2026, the professional response is the evergreen retainer. To manage the risk of these high-maintenance cases, attorneys require a significant sum of money to be kept in a trust account at all times. As the attorney bills their hours, the client must immediately replenish the fund. If the fund isn't replenished, the work stops. This isn't just a business tactic. It is a professional boundary designed to ensure that the attorney is being compensated for the extreme emotional labor required to manage a volatile person. Furthermore, we are seeing a shift in how attorneys handle the digital theater of 2026. Social media has turned every divorce into a public performance. A professional attorney today has to act as a digital brand manager for their client. They must issue a set of professional don'ts that are more important than the legal dose. Don't post about your new partner. Don't post about your luxury purchases. Don't vent about the judge on a private Facebook group that is never actually private. The attorney must monitor the digital footprint of both parties, looking for the smoking gun of a bad parenting decision or an undisclosed vacation that proves an ability to pay more support. The case study of the professional attorney also involves the management of expert witnesses. In a complex divorce, the attorney is the conductor of an orchestra. They are managing the forensic accountant, the vocational expert, the custody evaluator, and sometimes even a private security detail for high-profile clients. Each of these professionals brings a different piece of the puzzle, and the attorney's job is to synthesize all that data into a single, persuasive narrative for the court. This requires a level of project management that was never taught in law school a century ago. It is the evolution of the lawyer from a solo litigator to a chief executive of a temporary legal enterprise. As we look at the ethics of the profession, we must also address the rise of unbundled legal services and the push for access to justice. While the top 1% of divorces are handled by professionals like Marcus, the historical trend for the middle class has been a move toward DIY divorce. This has forced the professional attorney to specialize or die. The generalist, who handles a few divorces a year, is becoming a thing of the past. In 2026, the market demands specialists who understand the intersection of family law with intellectual property, international tax treaties, and emerging reproductive technologies like embryo ownership. The century of professionalism has turned the divorce attorney into a highly specialized, emotionally resilient, and technologically advanced operative. They are the ones who have to keep their head when everyone else is losing theirs. But no matter how good the attorney is, and no matter how much data they have, the entire process eventually reaches a bottleneck. It is the moment when the spreadsheets and the psychological profiles are laid bare, and a single person, a judge, has to make a decision that will echo for decades. In the next part, we are going to go inside the black box of the American courtroom. We will look at the professional reality of the family court judge. How do they make a decision on custody in 15 minutes? What does the evidence actually look like in a digital courtroom in 2026? And why is the day in court that everyone wants often the worst professional mistake a client can make? The theater of the law is about to begin, and the results are rarely what you see on television. The bench has its own set of rules, and they are colder than you think. To step into a family court in 2026 is to witness the ultimate industrialization of human tragedy. While television dramas have spent decades conditioning the American public to expect hour-long monologues and dramatic reveals, the professional reality of the bench is governed by a much colder metric: the docket density. In major metropolitan areas like Los Angeles, Chicago, or Phoenix, a single family court judge may be responsible for managing over 500 active cases at any given time. This historical trend of administrative bloat has transformed the role of the judge from a thoughtful arbiter of justice into a high-speed triage officer. When a divorce attorney brings a client into this environment, they are entering a system where the most precious commodity is not truth, but time. Imagine a case study involving Kevin and Maria. They have been married for 18 years and are fighting over a complex set of assets and a high-conflict custody schedule. After 2 years of litigation and $60,000 in legal fees, they finally get their day in court. They expect a deep, searching inquiry into their lives. Instead, Judge Miller, who has already heard 14 motions for temporary support before lunch, gives them a total of 3 hours for their entire trial. This is the professional reality of 15-minute justice. In this environment, the attorney's professional skill is not in their ability to argue, but in their ability to curate. They have to decide which 3 pieces of evidence out of 1,000 are the most likely to survive the judge's exhausted scrutiny. The first step-by-step hurdle in the courtroom is the gatekeeping of evidence. In 2026, the rules of evidence have become a minefield for the unprepared. A professional attorney knows that a judge will not look at a printed screenshot of a text message unless it is properly authenticated. This requires a professional chain of custody. If Maria wants to prove Kevin was being disparaging in a WhatsApp thread, her attorney must use forensic software to extract the metadata, proving the message wasn't manipulated or edited. This is where many pro-se litigants, individuals representing themselves, fail. They arrive with folders full of printouts that the judge legally cannot consider because they constitute hearsay or lack a foundation. The professional divorce attorney acts as the filter, ensuring that every piece of information presented to the bench is legally invisible to the rules of exclusion. Behind the scenes, we must look at the professional role of the law clerk. In 2026, the law clerk is often the most influential person in the courthouse that the client will never speak to. Because judges are so overwhelmed, they rely heavily on their clerks to read the 200-page trial briefs and summarize the legal arguments. A masterclass-level attorney understands this and writes their briefs specifically for the clerk. They use clear headings, concise case law citations, and executive summaries. Historical trends suggest that a judge's initial impression is often formed not by the testimony in court, but by the bench memo prepared by a 26-year-old law clerk the night before. If your attorney hasn't professionally engaged with the clerk's office to understand their specific filing preferences, your case is already at a tactical disadvantage. The 2026 courtroom itself has undergone a professional digital transformation. Remote hearings, which became a necessity in the early 2020s, are now the standard for almost everything except final trials. This has changed the psychology of the bench. When a judge is looking at Kevin and Maria through a Zoom window, the human element is flattened. It is much easier for a judge to make a cold, formulaic decision when they are staring at a grid of faces on a monitor. Professional attorneys have had to adapt to this by becoming masters of digital presentation. They use shared screens to highlight specific lines in a financial affidavit, ensuring the judge's eye goes exactly where it needs to go in the 30 seconds of attention they are likely to give that document. This brings us to the concept of judicial discretion and the best interests of the child standard. In the professional legal world, discretion is a broad, often unpredictable power. Because family law is a court of equity, judges have a massive amount of leeway to decide what is fair. Case studies show that 2 different judges can look at the exact same set of facts for Kevin and Maria and come to diametrically opposed potential outcomes. One judge might be a proponent of the 2-2-5-5 custody schedule, believing it provides maximum stability. Another judge might have a personal bias toward week-on, week-off rotations for teenagers. A professional attorney doesn't just know the law, they know the judge. They research the judge's past rulings, their professional temperament, and even their personal background to tailor the argument to that specific individual's philosophy of the family. We also see a historical trend known as the status quo bias. In 2026, judges are increasingly hesitant to disrupt whatever arrangement has been working during the separation. If Kevin moved out and has been seeing the children every other weekend for a year while the case was pending, the judge is professionally inclined to keep that schedule in place unless there is a compelling reason to change it. The attorney's professional task during the temporary orders phase, which happens at the very beginning of the case, is actually more critical than the final trial. If you lose the status quo battle in the first 30 days, you are fighting an uphill battle for the next 2 years. The bench values stability and predictability over almost everything else. Furthermore, we must address the professional reality of the burden of proof. In a civil divorce case, the standard is the preponderance of the evidence, meaning something is more likely than not to be true. This is a much lower bar than the beyond a reasonable doubt standard used in criminal law. However, in 2026, the volume of digital noise makes it harder to reach even that lower bar. A judge is looking for a tiebreaker. This is why the professional attorney uses expert witnesses, such as a court-appointed evaluator or a financial forensic, to provide an objective third-party perspective. The judge, who is not an accountant or a psychologist, professionally leans on these experts to justify their decisions. If the expert says the plan is sound, the judge is shielded from being overturned on appeal. The final professional truth of the bench is that the judge actually wants you to settle. A trial is viewed by the court system as a failure of the professional process. In 2026, many judges will call the attorneys into their chambers before the trial begins and tell them exactly how they are planning to rule if the case proceeds. This is called a judicial settlement conference. It is a moment of extreme professional pressure. The judge might say to Maria's attorney, "I've read your brief, and I'm telling you now, I'm not going to award the lifetime alimony you're asking for. You have 20 minutes to talk to your client and settle, or we do this on the record and she might get even less." This theater of the law, with its high-speed decisions and digital disconnect, is why the most professional attorneys spend 90% of their time trying to keep their clients out of the courtroom. They know that once you step in front of that bench, you are surrendering your life to a stranger who is probably thinking about their next 4 cases. The goal is not to win the trial. The goal is to leverage the threat of the trial to get a professional settlement. But what happens when the gavel finally falls? What happens when the decree is signed and the professional machinery stops? Most people think that is the end. In the next part, we are going to look at the professional aftermath, the post-decree world. We will explore the historical trends of the modification battle, the rise of the enforcement action when one party refuses to pay, and the professional reality of the lifelong legal tie. The divorce might be over on paper, but in 2026, the legal hooks can remain in your life for decades. We are going to dive into the world of the non-compliant ex-spouse and the professional strategies for finality. The paperwork is signed, but the war for compliance is just beginning. The finality of a divorce decree is one of the greatest misconceptions in the American legal system. In 2026, a signed judgment is often viewed by professionals not as a finish line, but as a roadmap for potential future litigation. Historical trends show that nearly 40% of high-conflict cases return to the courtroom within 3 years of the initial decree. This post-judgment phase is where the professional divorce attorney transitions from an architect of separation into an enforcer of obligations. When the ink dries on the paper, the legal bond is severed, but the administrative and financial ties often remain active for decades, requiring a specialized set of professional strategies to manage non-compliance and the inevitable shifts of human life. Imagine a case study involving a character named Alex. Alex finalized a divorce in early 2024. The decree was comprehensive, covering everything from the division of a tech-heavy investment portfolio to a detailed 2-2-5-5 parenting schedule for 2 young children. By the middle of 2026, however, the reality on the ground has shifted. Alex's ex-spouse, who was ordered to pay $5,000 a month in combined spousal and child support, has stopped making payments, citing a career setback due to the rapid integration of artificial intelligence in the financial sector. Simultaneously, the ex-spouse has filed a notice of intent to relocate 300 miles away for a new job opportunity. For Alex, the war for compliance and the battle to maintain the status quo are just beginning. The primary professional tool in this arena is the motion for contempt, often referred to as an enforcement action. In 2026, a professional attorney doesn't simply send a demand letter when payments stop. They initiate a multi-step legal process designed to bring the power of the state down on the non-compliant party. Step 1 in this process is proving the 3 prongs of contempt: the existence of a clear and unambiguous court order, the party's knowledge of that order, and their willful violation of it. The attorney must meticulously document every missed payment, cross-referencing bank statements with the court-ordered payment schedule. If the ex-spouse claims an inability to pay, the burden of proof often shifts. The professional attorney will use forensic tools to analyze the ex-spouse's 2026 digital footprint. Did they stop paying support, but continue to post photos of a luxury vacation on social media? Did they claim unemployment while their LinkedIn profile shows they have taken on a high-paying consulting role? This is a professional intelligence operation. If the court finds the party in contempt, the potential outcomes range from a judgment for the total amount owed, known as arrears, plus interest, to the suspension of professional licenses, the seizure of passports, and in extreme cases, incarceration. To bypass the volatility of a non-compliant individual, the professional attorney uses the income withholding order, or IWO. In 2026, this is the gold standard for finality. Instead of waiting for a check that may never arrive, the attorney serves a legal notice directly to the ex-spouse's employer. Step by step, the employer's payroll department is legally required to divert the support amount from the paycheck to a state collection unit before it ever hits the ex-spouse's bank account. This removes the human element from the transaction, turning support into a structured, automatic obligation. However, for self-employed individuals or those in the gig economy, the attorney must be more creative, often seeking a court-ordered lien against property or a freeze on brokerage accounts. We must also address the professional complexity of the modification of orders. The law recognizes that a decree written in 2024 may not be equitable in 2026. The legal threshold for changing an order is a substantial and material change in circumstances. This is a high bar. A professional attorney representing Alex in 2026 must argue that the job loss isn't just a temporary dip, but a permanent shift in earning capacity. Conversely, if Alex's attorney is defending against a downward modification, they will look for evidence of underemployment. This involves a vocational evaluation, where an expert analyzes the job market to prove that the ex-spouse is capable of earning more than they claim. They look at current salary data for 2026, the availability of remote roles, and the transferability of the ex-spouse skills. Then there is the relocation battle, perhaps the most emotionally charged professional challenge in family law. In a 2026 economy where remote work is ubiquitous, the desire to move for lifestyle or family support reasons has hit an all-time high. When Alex's ex-spouse announces a move 300 miles away, the attorney must perform a move-away analysis. This is not a simple yes or no. The professional attorney must analyze the best interests of the child based on a specific set of statutory factors: the distance of the move, the impact on the non-relocating parent's relationship, the quality of schools in the new location, and the child's existing community ties. The attorney's job is to draft a modified parenting plan that accounts for the distance. This includes the professionalization of the long-distance schedule. Instead of every other weekend, the attorney might propose a block time schedule where the child spends the entire summer and every major school break with Alex. They also negotiate for travel costs, often seeking a deviation in child support to cover the expensive reality of monthly flights or long drives. In 2026, these orders also include digital visitation clauses, mandating specific times for high-fidelity video calls to maintain the parental bond across the miles. Historical trends suggest that the economics of post-decree litigation are often a deterrent. A professional attorney performs a cost-benefit analysis for their client. If the ex-spouse owes $2,000 in medical reimbursements, but the legal fee to recover it is $5,000, the attorney must advise on the most efficient path. This often leads to the use of a parent coordinator, a neutral third-party professional with the power to make binding decisions on minor disputes without a court hearing. By 2026, many high-conflict decrees include a mandatory parent coordinator clause to prevent the court from being bogged down by arguments over who pays for soccer cleats or which parent picks up the child on a Tuesday. Finally, we see the rise of the set-aside motion. If Alex discovers in 2026 that the ex-spouse hid a significant asset, perhaps a block of early-stage equity or a digital wallet that wasn't disclosed during the 2024 trial, the attorney can move to reopen the financial portion of the case. In many jurisdictions, there is a statute of limitations for this, but if fraud is proven, the professional attorney can seek to have the original property division voided and a new, more punitive distribution ordered. The search for the truth doesn't end when the judge signs the final order. It continues as long as the digital trail remains warm. The post-decree world is a landscape of constant maintenance. The professional divorce attorney in 2026 is no longer just a litigator. They are a life cycle manager, ensuring that the legal framework built during the crisis of divorce can withstand the pressures of time, career changes, and geographical shifts. They are the ones who turn a piece of paper into a functioning reality, providing the structure that allows families to move forward, even when the relationship has failed. But as we look at the mechanics of enforcement and modification, we realize that the profession itself is standing on the edge of a massive transformation. The century of professionalism we have mapped out, from the keyhole-peeping investigators of the 1920s to the forensic digital analysts of today, is about to face its greatest challenge. The tools, the ethics, and the very identity of the divorce attorney are being reshaped by forces far beyond the courtroom. In our 10th and final part, we are going to look at the future of the profession. We will explore the rise of AI-driven mediation, the potential for decentralized legal systems, and the legacy of the people who spend their lives in the trenches of human heartbreak. What will the divorce attorney look like in another 50 years? We are going to close the loop on this century of professionalism and look toward the horizon of the next. The final chapter of the masterclass starts now. As we peer into the remaining years of this decade and look toward the mid-century mark, The professional identity of the divorce attorney is undergoing its most radical transformation since the invention of the no-fault statute. In 2026, we are standing at the precipice of the post-human legal era, where the century of professionalism we have mapped out is converging with the age of artificial intelligence and decentralized systems. To understand what comes next, we have to look at the emerging historical trends that are currently moving from the fringe of the legal tech world into the center of the American courtroom. The professional of the future is no longer just a master of the law. They are the auditor of the algorithm. Imagine a case study involving a character named Jordan living in Seattle in late 2026. Jordan and their spouse have decided to end their 10-year marriage. In the previous decades, this would have triggered the massive manual discovery process we discussed in Part 2. But Jordan's professional attorney now utilizes a generative AI legal platform that functions as a high-speed forensic operative. Step by step, the software integrates with Jordan's banking APIs, cloud storage, and even their smart home data. In less than 60 seconds, the system produces a comprehensive marital balance sheet that flags every anomaly, every potential hidden asset, and every historical trend in their spending. The attorney's professional role has shifted from the person who finds the data to the person who explains the nuance of that data, to a human judge. This shift toward automated discovery is creating a new potential outcome in family law: the instant settlement. We are seeing the rise of predictive justice, where software analyzed by professional attorneys can project a judge's likely ruling with a high degree of accuracy, based on thousands of similar cases in the same jurisdiction. Jordan's attorney can now present a data-driven report that says, based on the last 5 years of rulings by Judge Miller, there is an 85% likelihood that your alimony will be set at $4,000 for 6 years. This level of professional certainty is driving a historical trend toward pre-litigation resolution. If both parties can see the likely end of the movie before it starts, the incentive to spend 2 years and $100,000 in legal fees evaporates. However, the professional of 2026 must also navigate the dark side of this technology: the deepfake and the digital fabrication. As we look at the future of evidence, the divorce attorney has had to become a specialist in digital authenticity. Imagine if Jordan's spouse presents a video of Jordan making a damaging admission regarding custody. In the past, video was the ultimate truth. Today, the professional attorney must hire a digital forensic expert to analyze the frame rates, the lighting consistency, and the metadata to prove whether the evidence is a sophisticated AI-generated forgery. The battle for the truth is moving from the witness stand to the server room, and the attorney is the gatekeeper of that process. We must also address the rise of the smart contract in family law. Historical trends suggest that the biggest point of friction post-divorce is the transfer of funds, alimony, child support, and equity buyouts. In the next decade, professional attorneys are beginning to draft decrees that are encoded directly into the blockchain. Imagine a smart contract that automatically triggers a child support payment the moment Jordan's paycheck hits their account. If the payment is missed, the contract could automatically trigger a lien on a secondary asset or notify the court's enforcement division. This professionalization of compliance removes the need for the expensive and high-conflict contempt motions we explored in Part 9. It creates a system of self-executing justice that provides a level of finality that was previously impossible. But as the math becomes more automated, the professional value of the human attorney is actually increasing in the realm of emotional and moral complexity. AI can calculate a 50-50 split of a retirement account, but it cannot navigate the silent grief of a parent losing half their time with a child. It cannot understand the cultural nuances of a multinational family, or the psychological impact of a spouse's long-term illness on the equitable distribution of assets. The professional divorce attorney of the 2030s and 2040s will likely be a hybrid professional, someone who uses technology to handle the administrative and financial heavy lifting, while dedicating their human hours to high-level strategy, crisis management, and the preservation of the family's psychological integrity. We are also seeing a historical trend toward the internationalization of the profession. As the world becomes more globalized, the divorce attorney is increasingly handling cases that span multiple continents and conflicting legal systems. A professional in 2026 might be managing a case where the marriage happened in New York, the assets are in a Singaporean trust, the children are in school in London, and the parties are currently living in Dubai. This requires a level of professional expertise in private international law and treaty interpretation that was a rarity just 20 years ago. The century of professionalism is moving from the local courthouse to a global legal network. As we look back at the 100-year journey we have taken in this masterclass, we can see a clear trajectory. We moved from the era of moral fault and private investigators to the era of no fault and financial forensics, and finally into the era of digital intelligence and automated resolution. The profession of the divorce attorney has survived because it provides something that no society has yet been able to automate: a structured exit from the most complex contract a human being can enter. The legacy of the divorce attorney is not the volume of files they have closed or the amount of money they have moved. It is the professional standard they have upheld in the middle of chaos. They are the ones who have spent a century ensuring that when a family unit breaks, the individuals involved are protected by a system of rules rather than the whims of emotion. They are the architects of the new beginning. As we close the book on this century of professionalism, we recognize that while the tools change, from the fountain pen to the smart contract, the mission remains the same: the pursuit of a fair and functional end to a shared story. The evolution of the family law professional is a mirror of our own evolution as a society. We have become more data-driven, more efficient, and more focused on the long-term well-being of the next generation. The future of this profession is not in the courtroom, but in the creation of systems that prevent the need for the courtroom in the first place. The next 50 years will likely see the divorce attorney transition into a lifecycle consultant, someone who helps individuals navigate the beginning, middle, and end of their domestic partnerships with the same level of professional rigor we apply to our most important business ventures. But this deep dive into the world of the divorce attorney was only the first chapter of our exploration into the professional machinery that runs the United States. While we have mastered the architecture of the exit, there is another world of high-stakes professionalism that operates in the shadows of the American economy. A world where the split isn't between spouses, but between the public and the private, and where the costs are measured in billions rather than thousands. In our next deep dive series, we are moving from the living room to the boardroom. We are going to explore the century of the corporate whistleblower. We will look at the professional bounty hunters of the SEC, the high-stakes world of the False Claims Act, and the attorneys who risk everything to expose the secrets of the world's largest entities. If you thought the battle for a suburban home was intense, wait until you see the war for the soul of the global marketplace. The next part of our professional masterclass is just beginning. Stay tuned as we unmask the secrets of the whistleblowers.